Thank you, everybody, for showing up today for our legislative update. We're excited to have you all here. Couple things I just want to bring to your attention. SCWA's webinars and seminars, advocacy, working groups, help desk services, and all their activities are primarily funded through the payment of dues by member schools. We'd like to thank all the schools that have contributed to supporting us and our mission to be able to host seminars like this. I'd also like to put on your radar that our annual SCWA members meeting is going to be held this fall. We will be sending information regarding this in more detail over the next month, so please watch for those emails. We would love for you to be able to attend, and to be able to attend, you must be a dues-paying member to SCWA. If you have any other questions, please feel free to contact us and reach out at any time. We look forward to talking with you more. Enjoy today's seminar. With that, I will pass it over to Amy Lautenbach.
Well, good morning, everyone, and welcome to our legislative update. You've already met our team. As you are likely aware, School Choice Wisconsin is led by our president, Nick Kelly, and Carol Shires and myself are the two registered lobbyists that are interacting and advocating for members in Madison, and also working behind the scenes and tracking legislative proposals and DPI administrative roles. So as we look back to the legislative session that just adjourned, you can see at the bottom of your screen, the legislature is not scheduled to reconvene until January 6th of 2025. That's going to be a whole new set of legislators. So the regular session is adjourned unless there is an extraordinary session or a special session called. There will be no other activities aside from committee work and administrative rules. No bills. All the bills from the prior 13 months have been disposed, and everything will restart in January of 2025. So looking back at the session, during the course of the last 14 months, approximately 1,200 bills were introduced, really a total of 2,400, because you'll normally have an assembly bill accompanied by a Senate companion bill. So about 2,400 bills to track. Of those bills, 272 were signed into law. 76 bills were vetoed. And when you look at the whole of all the bills introduced, approximately 20% of bills introduced affect schools or education policy. And we kind of use what we would look at like a funnel to get a watch list together. So about 200 bills are on our watch list. And then if we take that down another level, we really track and engage on a smaller number of bills. This year it was about 32 bills, but we're always tracking some bills, for example, that are introduced that have a carve out for private schools. We're always watching to see if those get added back in. So we have a team internally and with our boards that helps me navigate that process. And Carol and I keep people updated so we can make sure that we're all hands on deck when it's time to testify or engage with legislators. So we started out the session with legislative priorities for School Choice Wisconsin action. We advocated for a per pupil payment increase. We also worked with legislators to propose a bill that would decouple choice schools from the school funding formula and property taxes. And then we also worked for months and months, Carol and I and others on our team with the Department of Public Instruction on a package we called Strengthen and Simplify. So of those three priorities, our number one priority, the per pupil payment increase, we were successful in attaining a historic level of closing the gap funding for schools in the choice and charter programs that was signed into law in June. And you will note on the next slide that the biennial budget sets the per pupil payments for 2023 and for 2024-25. And then when the session reconvenes, the level of payment for 24-25 2024 to 2025, that will be the base payment. Increased payments may be authorized in a future budget, in a future legislature. They may also be reduced, although we haven't seen that happen. What we want to convey with this slide is that you can be confident in this 2024-2025 payment to use for your budgeting purposes. It builds automatically based on a formula included in what's called indexing off of the 2023-2024 payment. For the 2025-2026 school year, depending on what happens with the recent court challenge to Governor Evers' 400-year veto, there may be additional per pupil increases that are automatically included based on current law, but we don't know that yet. So we're just encouraging folks to focus on that 2024-2025 payment, and we will engage again in the next budget process to advocate for adequate funding for our schools. Decoupling, we were successful in getting a bill introduced and passed in the assembly. We're going to have more work to do on that next session. I'm not going to spend a lot of time on this except to say that effort wouldn't have provided additional funding for our schools. It would have just eliminated a whole lot of complexity in how students are funded through local property taxes. Our second priority that is going to be carried over into next year was the Strengthen and Simplify bill. Again, a bill was introduced. We had the support of the Department of Public Instruction. We had a lot of momentum building for changes to current law regarding an automatic re-enrollment process, a short-term substitute teaching permit for choice schools. The programs would have been combined and aligned to make your reporting a lot more streamlined. And again, this will be a priority next session. Our takeaway from the legislative session was it was very successful, but we also know that some of our opponents were very displeased with the success that they saw with the increase in the school funding. And even though the second two priorities didn't have anything to do with funding, the education establishment really pushed back on anything that would have been perceived as a benefit to choice schools. We're going to continue to make our case and work with legislators on both sides of the aisle. For example, the DPI improvements, that's something that would have benefited the administration as well as private schools, and decoupling would have benefited public schools. We're going to go back and make our case for those changes next session. The bills that affect choice schools, there were really 5 bills, including the increased funding that impacted choice schools. The first one I'm going to talk about, and it's going to take a little bit of time, is the literacy bill. We have had a lot of questions about this from folks on the webinar, and I want to make sure that we have the time to go through this. Some of the information is going to be repeated because it's carried through in these slides, and you're going to be able to download these slides and use them as a reference document because, again, it was a pretty robust set of policy changes, and there have been a lot of conversations inside of DPI. There is a lawsuit pending and a counterclaim pending. The things I'm going to share with you are things that we know that are going to impact your schools. There are some deadlines that are going to impact your schools, and there are some things that we just don't know yet right now, but I'll give you the most current information possible. So the literacy bill. That is Wisconsin Act 20. Here's a summary. It makes changes to early literacy instruction, curriculum, assessments and interventions, as well as teacher licensing and preparation. It's important to note that many provisions of Act 20 do not apply to choice schools. And it's also important to note that if you are an SNSP only school, so the only students that you accept are students with special needs, Act 20 does not apply to your school. So there are really 3 main components of the literacy bill that are applicable to private schools as listed below. Curriculum. The bill requires schools to provide science-based early literacy instruction in both universal and intervention settings. The bill also prohibits the use of 3Qing for instruction and curricula in grades K through 3. There are grants that are described in the bill that will be made available to all schools, public and private choice schools. Schools do not have to choose from a list of curriculum. They can use any curriculum that is science-based. If they wish to choose curriculum from an approved list by the Literacy Council, they will have grants that they may be able to access. I'm going to go into more detail on that on the next slide. I do want to talk briefly about the promotion policy. The promotion policy does apply to private choice schools. We'll talk more about that in a future slide, but DPI will provide a model policy, and it is our expectation that we will have the opportunity at School Choice Wisconsin Action to look into what a model policy might look like for private choice schools so that they can use that as their own model as they incorporate their policy on how they are going to provide intervention services for students at low proficiency levels. The third element of the bill that private schools may be able to benefit from if they choose are reading coaches. So at least 2 of the lowest performing private choice schools will be offered literacy coaches at no cost to them. It is important to note that if a school is identified for a reading coach assignment, the school is not required to accept that assignment or accept that assistance. It's optional. So a little bit more about the private school, about the curriculum grants. So on this slide is a list at the bottom of grant eligible early literacy instructional materials. So that's a long way of saying your curriculum and whatever supplies and things you might need to implement that instructional material. So according to DPI, and the link is right at the top of this slide, that you can go in and check again because they do periodically update information. But according to DPI, the details will be available soon. And there's also an important note in here to schools that if you bought your curriculum from March 11th forward and it is in either any of those 4 categories, you are eligible for partial reimbursement, but there is no guarantee that the percentage of reimbursement will be the maximum allowed under the law, which is 50%. So for example, you purchase a $20,000 package, you may be eligible for up to $10,000, but we're expecting that those amounts are going to be prorated based on demand for the program. So there's no guarantee in the specific amount of funding, and it's likely that you wouldn't be reimbursed until 2026. That's one of the lawsuits that's pending. And it's also the result of some delays in the Reading Council approving the list of eligible materials. At this time, these 4 have been approved. It is possible that other curriculum will be added to the list. Act 20 promotion policy. We've gotten a lot of questions on this as well. And again, the link to the Act 20 FAQs is at the top of your screen if you want to go back and check for updates. So schools have asked, do you have to retain a 3rd grade student based on reading assessment scores? According to DPI, no. DPI is required to create this model policy so the schools can look at it and use it or adopt something of their choosing. And they are required to adopt it and implement it by July 1 of 2025. Beginning in September of 2027, that's when the promotion policy piece comes into play. That is going to require that the interventions that you specify in your promotion policy are made available to that pupil if they are advancing from 3rd grade to 4th grade without satisfying the criteria in the policy, which is a low score on the reading achievement test. It's a lot of information in that slide. Again, when we get the model policy from DPI, we're going to try to do our best to make private schools a template that they can use for their own consideration by their own boards for what that policy is going to look like. Next slide is going to talk about the interventions that choice schools must provide. So if students are performing or scoring below grade level on the state reading tests, you're going to have to notify the parents that you're going to be providing these extra instructional services. You'll be monitoring their progress, and you're going to be providing an intensive summer reading program. So again, details of those things are unknown, and we will be monitoring what that looks like. But according to DPI, this intensive instructional services means things like targeted one-on-one instruction or smaller group learning or increasing the level of engagement or encouraging that pupil to engage in independent reading and writing. So more guidance to follow. There are good cause exceptions that are allowed under the policy, and you can access those in the FAQ links. A lot of that has to do with the students with an EIP, for example. So the next slide is going to talk about general requirements for private schools. So schools may not purchase or implement 3Qing instruction and curricula for use in grades K through 3. Most of you all already know that. Most of you all are not using, if not all of you, are not using curricula that implements 3Qing instruction. If you would like to replace your curricula with one of the 4 identified packages that are eligible for reimbursement, private schools are eligible to do that. Schools do not have to choose from a DPI approved list. That part of the bill was removed very early on in the legislative process. We were very staunchly opposed to any DPI list applying to curriculum for private schools. So that is something that I want to really make clear to folks, that you can choose the curriculum that you wish to use at your school, as long as it doesn't incorporate 3Qing into the instruction. When you are administering your statewide reading assessment, if you are using the all student report card, you are obligated to administer that test to all students. That's current law, but it is restated in the bill and in the guidance documents. Report cards. Report cards going forward will include reporting data from the 3rd grade state reading test, including the percentage of students reading at grade level by the end of 3rd grade. That will be incorporated onto your report card. And then finally, as we talked about, you will be required to adopt and implement a policy for promoting students from 3rd to 4th grade, including that reading intervention work if students are not reading at grade level. So that was a lot, but these future slides are going to provide you with the information that a lot of folks have asked about, which is what provisions of Act 20 do not apply to private schools. Number 1, universal screening and diagnostic assessments. Private schools are not required to implement universal screening and diagnostic assessments. Public schools and independent charter schools are required to implement those screenings and assessments. Private schools in the choice program are not. Professional development. So this is opportunities that you have to provide for teachers so that they can get the most up-to-date science-based reading, education, professional development. That requirement for professional development does not apply to private choice schools. Personal reading plans for struggling readers do not apply to private schools. The interventions, which are whatever you describe in your policy, are required. Notifying the parent that the reader is struggling is required. But a personal reading plan has a specific meaning and a whole lot of structure and notifications around it, and the parent has to sign off and the school has to sign off. Those personal reading plans are not required for private choice schools. And finally, DPI enforcement. Act 20 contains a complaint mechanism. It contains some DPI enforcement mechanisms. Those provisions apply to public and charter schools only, and they are not required for private schools. So again, I'm going to restate some of these things in a different way so that you can have them for your own reference. Choice school staff are not required to participate in a required reading training. Choice schools are not required to administer the reading readiness screener or the diagnostic assessments. Choice schools are not required to create personal reading plans. So in your policy, the student's score on the state reading test is going to trigger the requirement to provide those extra supports. For public schools and charter schools, it's going to be failure to complete this personal reading plan and a whole bunch of things that are associated with the screening and diagnostic assessments that do not apply to choice schools. Again, if your school is selected for a statewide early literacy coach assignment, you are not obligated to accept that placement. And finally, public and charter schools, if you hear this in the school chatter world for public or charter schools, there's other reporting requirements that they have for their report cards that do not apply to private choice schools. That has to do with remediation plans and other things like that being publicly available. So that concludes Act 20. We will accept and encourage questions at the end of the presentation. Again, try to put this in a couple different formats, depending on what works best for you for sharing this information with your team going forward. And we will have access to the slides. So the next bill affecting all schools I want to talk about is the school safety reporting bill. So this bill was part of Act 12, which was the shared funding bill that was passed very early on in the legislative session. So if you are a high school and you are on this call, Act 12 applies to you. If you are a K-8 school, this bill does not apply to you. If you are a K-12 school, this bill would apply to your high school buildings. The bill requires high schools, including private choice high schools, to report statistics regarding criminal incidents and file an annual report to DPI. So the level of crimes that would require this type of reporting include homicide, sexual assault, disorderly conduct in violation of a municipal ordinance. The list is on your screen. If those things, burglary or arson or possession of a controlled substance or a firearm, occurs on property owned or leased by the school, occurs during school hours at a school sanctioned event or during transportation of pupils to or from a school, and is reported to law enforcement and results in the filing of a criminal charge or municipal citation, that incident would need to be reported annually to the Department of Public Instruction. So this first applies to incidents that occur in the 2024-2025 school year. So that would be coming up in the next several months. Unfortunately, what we're hearing is that the Department of Public Instruction and the Department of Justice are kind of trying to work out how they're defining these incidents. So guidance documents and administrative rules or anything that schools can use as a basis to inform their process for creating these annual reports has not been finalized. You likely remember when the bill was passed. So back in August, you probably got an email from DPI because DPI is required to inform private schools of laws that are passed that affect them. And DPI was beginning to work on operationalizing these new requirements back then. And again, we don't have those guidance documents yet, but it is my understanding that they are in process and we will certainly keep you informed. But do keep in mind, if you have a significant incident that occurs on your property and it results in the filing of charges, you're going to want to remember that you're going to need to report that to the department in July of 2025. So this is something that you can at least reference in the unlikely event and unfortunate event that this would happen at your school. Another bill affecting private choice schools is Act 95, which relates to automatic University of Wisconsin acceptance. So the bill has requirements on the University of Wisconsin system schools, and it has requirements on private choice high schools. So again, this only applies to the upper level grades. What the bill is attempting to do is to say high performing students in public, private, charter, homeschool settings, those high performance students should have automatic admission access to the UW system. If they are in the top 10% of their class under the bill, they would be automatically admitted to any UW system school. If they are in the top 5% of their graduating class, they would be automatically admitted to the University of Wisconsin-Madison. Now, there are some qualifying guidelines that schools can use and schools must use. The bill, when it was first introduced, had a wide range of very confusing factors that would weigh into how students were ranked. Under the bill, the ranking is based on academic performance only, and it's based on GPA. So schools can use a weighted GPA or an unweighted GPA, but they must be uniform for all students. Choosing one or the other, having that information determined in advance. So the schools will be required to rank the top students, excuse me, at the end of 11th grade. So at the end of 11th grade, rank your students based on GPA, and these top performers would receive a notification from the school and noted on the pupil's transcript. So then they know when they apply that they will be guaranteed admission. Some of you may be asking yourself, well, what if someone happened to be in the top 10% at their school, but their GPA was only 2.3? The bill does have some cutoffs. I believe it's a 3.0 GPA ranking, so that we don't end up with low performing students ending up in the top 10% in certain situations. So again, it's a little bit of extra work on the part of the private choice schools. It's my understanding most schools do rank. If you don't and you have questions, we can certainly connect you with another school that does, or give you some other tips. But on the flip side, we have heard stories of private school students that are high performing not being accepted into institutions of higher education at the University of Wisconsin system. And so this will guarantee acceptance for those high performing students. The bill does not require virtual private schools to rank pupils. Those students can use their ACT scores for guaranteed admission. There's language in the bill about what percentile, I think it's what percentile they have to be in for ACT performance, and a few other things for homeschool students or they can use their national merit scholar status. Again, there is a little bit more information if you're interested, that I'd be happy to provide after offline. The final bill that relates to schools, or in particular relates to education providers and volunteers in a school setting. So the bill doesn't have any requirements specifically on private choice schools, but this is something that you need to be aware of, because the bill creates a definition of sexual misconduct. It makes it a class 1 felony for a school member, staff member, or volunteer to commit sexual misconduct against a pupil. So you will see on your screen, this is what is going to happen. An incident happens at a school. It involves a school staff member or a volunteer, and law enforcement is contacted. If that happens, the law enforcement agency needs to inform DPI if there is an alleged violation. It also needs to inform DPI if it receives a report from a mandatory reporter that constitutes a violation of sexual misconduct. They also need to provide the name of the person and the school. After that, things go through the normal legal and investigation process. In the event that a person is convicted of a Class H felony or higher, which would include sexual misconduct by a school or a staff person, they would lose their DPI license. There are also other felonies that are listed in the bill that would result in a teacher or educator losing their license. In the case of the other staff members or volunteers, as you know, if they do have some sort of a conviction, they would not be allowed to work in your school anyway. But again, this definition of sexual misconduct is explained further on the next slide. And these are the things that would constitute sexual misconduct. There's a definition of verbal conduct of a sexual nature, and there is a definition of physical conduct. I have an error. Physical conduct of a sexual nature on your screen. We had discussions at length with the authors of the bill. There was an example of an incident at a private school that was used repeatedly throughout the testimony. We were really disappointed in that because the intent of the bill, I think, was to make sure that individuals are properly trained and aware of what behavior is appropriate or inappropriate when you're working with minor students, and the conversations regarding the applicability of federal law in a private school setting was something that was mentioned at some of the hearings. At the end of the day, the definitions that were created in the bill are to make sure that bad actors are not allowed to teach in our schools. And again, I emphasize the training and the other requirements in the bill, but just like a lot of other legislation, our schools are not bad actors. Our schools are teaching science-based reading. Our schools are treating students with respect. And this was a bill that we just wanted to get as many questions answered so we can provide the right guidance to our students. There were a lot of groups like the Catholic Conference and others who were supportive of this bill, and it was passed with bipartisan support in both houses. Moving on to a handful of other bills of interest. So we've had a lot of questions about Act 60 relating to the financial literacy requirement for high school graduation. That bill does not apply to private choice schools. You are not required to have that half credit of financial literacy for your student to get a high school diploma. In fact, none of the requirements that public schools have relating to particular credit amounts for individual instruction, like you need X amount of credits for history or English, those requirements don't apply to private schools. Private schools have a different construct for consecutive curriculum and are able to make those determinations internally, not in accordance with the requirements that are applicable to a public school or a charter school. Similarly, the Hmong American Instruction Act does not apply to private choice schools. There was another bill that you may have heard about. It had to do with the availability of opioid antagonist kits, so those OAT kits in schools. The bill was introduced to require those kits in every school. The bill was modified to remove the mandate for the OAT kit to be available and stocked in every school. Instead, the bill was the provision, the provision that was included in the bill that passed simply provides civil immunity to schools if Narcan or another opioid antagonist is administered by school personnel or someone in the school. So unless there's malicious intent, civil immunity is granted to schools. There's no requirement to have Narcan at your school or maintain a usable supply. There was another bill relating to glucagon rescue therapy. This is kind of a moving target as new therapeutic methods become available. Again, the bill doesn't require anyone to do anything. It just creates an immunity from liability for schools if that sort of therapy, rescue therapy is administered at the school. And so there's these are bills that are, I think, intended to just keep up with the times and again provide those legal protections in a school setting for good good Samaritan types of activities. Those bills that I just covered are the only bills that pass that apply to private schools or things that you may have wondered if they applied to you or not. The next 5 bills that we're going to talk briefly about are bills that did not pass this legislative session that would have affected private choice schools. There was one bill that would have required a poster directing individuals that were victims of child abuse in the home, perhaps, or by a neighbor or another individual in their family. It would have advised that individual to contact their county human services office for help. It was a requirement that would have resulted in schools being mandated to post this child abuse awareness poster in every school building in their system. The bill has been introduced several sessions. It's never made it to the governor's desk, but it has gotten bipartisan support and has periodically gotten some legs. Of course, child abuse is something that folks are concerned about, but for private schools, we did make the case to the bill author that it wasn't that we wanted private schools to be able to advise students with their own caring adults and not just turn them over to county social services in the event that something was going on at home. So in addition to just being opposed to a mandate that required more administrative work, we also felt that that bill conflicted with potentially could conflict with the operating values of an individual private school. Cursive writing and civics instruction. Again, 2 mandates that were drafted to apply to public schools, choice schools, charter schools. One of the bills, the cursive writing instruction bill, it's been introduced in legislative sessions in the past. Typically, all of the school associations oppose it. In the case of the cursive writing instruction, was introduced late in the session. We knew it wasn't going to get a hearing, likely in the Senate or perhaps in either house, but it did get a hearing in the Assembly. So we're going to circle back and make sure we really talk to authors who introduce these bills and encourage them when they are looking at these bills to reintroduce them next session to carve out private schools from the get-go, because we are going to be beating the drum of autonomy and independence and freedom and innovation and all the things that make our schools great, drilling that into the heads of legislators so that they keep in mind that we're not a public school monopoly. We are a private school market, and what makes our schools great is because that they have that independence and that autonomy. And so we're hoping that the cursive writing instruction bill, the civics instruction bill, if those come back again, that they wouldn't apply to our schools. There was another bill that would have eliminated the immunity from prosecution for a librarian or an educator. Now, this bill was relating to them distributing inappropriate material, pornography. We've talked about the book bans and some of the other things. Our concern was potentially, if that bill passed, that we didn't want it to be weaponized to be used against religious schools. And so we shared those concerns with the author. The bill did not move out of committee, but we did feel like there was definitely a risk if the tables are turned, and there are different folks that are using these weaponizing these types of laws that religious schools could potentially have been targeted. So we opposed that bill. There were two other anti-school choice bill packages. These were the above four bills were bills that were introduced by and sponsored by Republicans. Um, in the case of the librarian educator bill, and in the case of the other three, um, the child abuse poster was bipartisan. The cursive writing and the civics was primarily Republicans. And then the two anti-school choice bill packages on the last one on the list, those were sponsored by Democrats. So again, when I go back to talking about our watch list, we have to take every bill and look at it and look at its likelihood of getting considered, but we also need to look at it to inform our strategies for future sessions, because in a future session, those with Democrats in charge of one of the houses of the legislature, those anti-school choice bill packages could actually get hearings or could actually get votes. And we want to make sure that that we are watching for bills that might pass this session, or we are also looking at ideas for future sessions that we want to make sure that we are armed with the information that we need to encourage folks not to sign on to these bills for a number of reasons. And we did that in the case of the anti-school choice bill packages, even though we knew that our friends in the legislature weren't going to pass bills to cap or wind down these programs. We wanted to make it really clear that we were paying attention, and that introducing bills to kick kids out of schools that they choose that they wouldn't be able to access otherwise was a really bad policy proposal.
Okay, Amy, the first one that came in from Heidi regarding Act 20, we had heard we needed to provide instruction for all K-3 staff and special needs support staff and principal. From this information, you are saying we do not. Our district is doing, I believe, 53 hours for this group mentioned. Will not doing this training limit our special needs students from receiving IEPs? Also, was this originally required for all schools?
I am unaware of the interaction between special needs students from receiving IEPs. I do know that some schools can use their title funding if they want to if they want to do some professional development work and they choose to, but the requirement for professional development for all schools regarding if it was in the original bill, I'm gonna try to look up in my memo while we're talking. But so your district is not required to do professional development under your private school is not required to do professional development for students and staff as a result of Act 20. Regarding if it was originally required for all schools, I'd have to look back at the original proposal, but I can do that while we're talking.
All right, the next question, Amy, that came through was from Katie for Act 12 school safety. If an incident occurs during a sporting event when a guest school community is on our school campus, would we report an incident that results in criminal charges because it's on our campus, even if the offending individual is not part of our school community? Conversely, if a member of our school community creates an incident resulting in a criminal charge on another school's campus, would that school report the incident rather than our school because it was on their campus and not ours?
Yes, it has to do with the property, not the school that the student attended. It's a reportable incident to law enforcement that resulted in a charge based on the school property where the incident occurred, not if they were a guest or not. It could be a spectator. It could be, I think we had an incident at a private school that something happened unrelated to any activity at the school, but the person just happened to be going through school property. All of those things, if it's on your school property, your school would be reporting it.
So her student, if there ends up being an incident at another location, she would not need to report it because it didn't happen on her location. Is that correct?
Correct.
Any other questions out there? Donna asks, Amy, regarding Act 95, are you concerned this will hurt students placing in the top 11 to 20% of high school, placing in the top 11 to 20% of high rigor schools will now be at a disadvantage because students in the top 10% of less rigorous schools will automatically be admitted? It seems this places those less qualified.
Donna, that's a great question. I mean, we did not engage on, we did actually, we did engage on this bill and had a proposed amendment, but there was, multiple amendments that were worked on in the committee and in the with the University of Wisconsin to try to address this issue. Not that we advocated for something different for private schools, but in the larger policy picture, there were members from a small, high-performing school district that were saying, I don't want this school to give an outsized advantage to, say, Milwaukee, because their top 10% might not be high performing, which is why they, I think, included the GPA threshold. And so the GPA threshold, I think, was meant to not overcompensate for that set of circumstances where you could have a high rigor school versus a low rigor school. So I could be concerned. It was something that was sort of, I watched along while committee members debated this, but the horse was kind of already outside of the barn. And I think they did their best to try to not make it using 5 different weighting factors, which would have been super complicated. But this was not a policy that we necessarily advocated for or liked.
Amy, Randy asks if there's a list of curriculum that 3Qing is in to make sure that they don't use it.
Great question, Randy. There is not. There are other states have created kind of a bad list. Wisconsin does not have one. I know there's the Lucy Calkins, I mean, there's some of the ones that education professionals probably are aware of, but there is no such list. And I can tell you, Assembly Bill 321, the Act 20 did not have, the bill is introduced versus the substitute amendment did not make any changes to carve out private choice schools. I don't think they were in there from the get-go. If that changes, I will update the slide, and if it helps, I will provide a reference in the slide deck before we distribute it to clarify that, because we've had that came from CISAs and a lot of other people we heard were getting information that professional development applied to them, and that's not the case.
Amy, Randy has a follow-up question. Do you happen to have a list of states that have that bad curriculum list as a reference?
I don't, but we can probably do some poking around, if that would be helpful to folks on the call. I know that the Mississippi, I mean, there are a handful of other states that I just can't think of them all off the top of my head, but I can we can reach out to the bill authors, even if they, or just Google it, but we'll see what we can come up with and share.
Okay, we've got a couple more minutes. Any other questions? Renee mentions that Ed Reports gives reviews. Thanks, Renee.
Thanks, Renee. Well, I really appreciate everyone taking the time. We'll be doing, again, sharing this information. If you have other input on things that you would like to see in the future, we'll probably do something again, talking about the election outlook, or what we're hearing in as far as our legislative priorities for the upcoming legislative session. Again, we're working a lot on providing new members with information about all the regulations that apply to private schools, and why our autonomy and our independence and our freedom and our flexibility are so important to our schools, so that legislators don't kind of come out of the box thinking that that just because we have the opportunity to have kids attend our schools on a state-funded scholarship does not equate to being treated the same as MPS or any other public school. And so that's really gonna shine through in everything that we do. And then we're gonna continue to work on the other priorities, strengthen and simplify, and decoupling for next session. And if you have other ideas of things that should be on the radar, please feel free to reach out.
Thanks, Amy, and thanks everyone for sharing your time with us this morning. Feel free to reach out to us at any point, scw@parentchoice.org. Have a great day.
Thanks.